son stepped in front of me before I could reach the entrance. "Dad, don't go in there," he said. His voice was calm, but his hand was flat against the glass door like he was holding back a flood. "Move, Daniel. I already handled it. Your money is fine. Trust me." Behind him, through the glass, I could see the branch manager watching us. Her face was not the face of someone who thought everything was fine. That was the moment I understood something was very wrong. My name doesn't matter for this story, so let's just say I was a man who spent 38 years fixing heating and cooling systems for a living. I started as an apprentice at 19 and retired at 62 with a small pension, a paid-off house, and a savings account I'd built one careful deposit at a time. I raised 2 children mostly on my own after my wife passed when they were still in high school. My daughter, Renee, moved 2 states away for a nursing job and called every Sunday like clockwork. My son, Daniel, stayed close. He worked in financial consulting, which I never fully understood, but he always dressed well and talked with the kind of confidence that made people nod along. When Daniel offered a few years back to help manage some of my accounts so I wouldn't have to worry about it, it seemed like a gift. I was slowing down. My eyes weren't what they used to be for reading fine print. My son had a business degree and clients who trusted him with real money. Why wouldn't I trust him with mine? We had a routine. Sunday dinners at my house, him bringing over folders of paperwork for me to sign, me barely glancing at them because he explained everything in simple terms. Just a transfer for better interest. Just some paperwork the bank needs. Updated, I nodded. I signed, I trusted. For a long time, life felt peaceful. I had my garden, my Thursday coffee with old coworkers, and a son who called himself on top of everything. I believed him completely. Looking back, the first sign was so small I almost laughed it off. My quarterly statement, which used to come in a blue envelope every 3 months, stopped arriving. When I mentioned it to Daniel, he said the bank had switched to email-only paperless statements, and that he'd already set it up for me since I didn't check email much anyway. At the time, I had no idea what that really meant. Then there was a phone call from a woman at the bank asking to confirm a recent authorization on the joint access line. I told her I hadn't authorized anything recently. She said not to worry. It was probably already resolved on their end, and hung up before I could ask what she meant by joint access. Joint access. I didn't remember signing up for that. A few months later, my neighbor mentioned she'd seen Daniel's car at the title office downtown. I asked him about it over dinner. He laughed and said he was just helping a friend with some paperwork and changed the subject to how the local team was doing this season. I let it go. The last flag came from my own memory. I distinctly remembered a certificate of deposit I'd opened years ago. A modest one meant to just sit and grow untouched. When I mentioned wanting to check on it, Daniel said it had already matured and rolled into a better fund he'd arranged. I nodded. I didn't ask which fund. Looking back, that was the moment everything changed, even though I didn't know it yet. It started with something ordinary. I needed to withdraw money for a roof repair. I walked to the branch I'd used for over 20 years, expecting a simple transaction. The teller typed my account number, paused, and asked me to wait while she got the manager. The manager, a serious woman named Ms. Alvarez, sat me down in her office and slid a folder across the desk. "Sir, before we proceed, I need to confirm something with you directly," she said. "There's a power of attorney on file, executed 8 months ago, that grants full transaction authority to Daniel, your son, on 3 of your accounts, including the ability to close accounts and redirect funds." I stared at the paper. My signature was there. I did not remember signing it. "There's also a home equity line that was opened against your property 6 months ago," she continued gently. $240,000 was drawn against it in stages. The most recent draw was 11 days ago. I felt the room tilt slightly, though I sat perfectly still. "Where did the money go?" I asked. She turned the folder to show me a list of outgoing wire transfers. Most went to an account under a company name. I didn't recognize Daniel's own consulting firm. The one he told me was doing so well on its own merit. The certificate of deposit I'd asked about closed 9 months ago. Never rolled into anything. The funds moved into the same company account. I sat with that folder for a long moment. Someone I had raised, fed, taught to ride a bicycle in the driveway, had gone into rooms I trusted and quietly taken apart everything I built. The person I trusted most had done this to me. I did not call Daniel that night. I did not scream into the phone or drive to his apartment. I went home, made tea, and sat at my kitchen table with a notepad. Because I decided early on that anger without a plan just burns the person holding it. The next morning I called a lawyer named Mr. Okafor, recommended by an old coworker whose own father had gone through something similar. He listened without interrupting, then explained things in plain words. A power of attorney is a tool, he said. It can be used to help or it can be used to take. What matters now is proving which one this was, and whether you actually consented to what's on that document. He explained that if my signature was forged or obtained through deception, the power of attorney could potentially be challenged and revoked. If money was taken beyond what any reasonable authority allowed, that could rise to financial exploitation of an older adult, which many places treat as a serious offense, sometimes criminal, sometimes civil, often both. We also brought in a forensic accountant named Priya, who specialized in tracing transfers between personal and business accounts. She explained that if the wire transfers all led back to Daniel's company account, and if that company had no legitimate service agreement with me, it would look less like managing my money and more like taking it. Together we built a plan with 3 parts. First, gather everything quietly. Old statements, the power of attorney document, any text messages or emails where Daniel referenced handling my accounts. Second, request the bank's internal records showing exactly when and how that power of attorney was filed, and whether the notarization was legitimate. Third, get Daniel talking on record, without him knowing how carefully I was listening. Mr. Okafor was clear about one thing. Nothing rushed. No accusations yet. Let him think you're still the trusting father he expects. I understood. Patience was going to be my strongest tool. For the next several weeks I became on the surface exactly the version of me Daniel was used to. At Sunday dinner, I mentioned I'd been a little confused about some old paperwork and asked him to walk me through it so I don't feel behind on things. He smiled, relaxed, and explained the power of attorney as standard stuff for peace of mind, even describing, in his own words, how he'd set it up, so nobody at the bank would need to bother me with small decisions. I asked innocent questions. So if I ever wanted to check the fund my CD went into, who would I even call? He answered casually, naming his own firm and even joking that he'd basically consolidated everything under one roof for simplicity. Priya had given me a simple, lawful method Mr. Okafor confirmed was allowed in our state. With one-party consent for recorded conversations, I could record our talks openly on my own phone, sitting on the table between us. Since Daniel already knew, I sometimes recorded family dinners for memory's sake, a habit from years back when my hearing started fading. Over 3 dinners I collected clear recordings of him describing the transfers, the CD closure, and the home equity draws, always in his own confident, unbothered voice. I made copies of every relevant statement. Priya matched the wire transfer dates to deposits made directly into Daniel's company operating account, not into anything resembling an investment vehicle. The picture was no longer confusing. It was complete. Each time Daniel spoke so easily about what he'd done, thinking I simply didn't understand banking, I felt something steady settle inside me. This would come back to him carefully and fairly, but it would come back. I invited Daniel and Renee, who flew in for what I told her was an important family matter, to the house on a quiet Saturday evening. Mr. Okafor advised having a neutral witness present, so Renee's presence served both as family support and as an honest observer. We sat at the same table where Daniel had explained everything so casually weeks before. I placed the folder in the center of the table. Daniel, I want to talk about the power of attorney, the home equity loan, and where my CD went. He smiled the way he always did. Ted, we already went over this. We did, I said, and I have it recorded, along with the bank's documentation and an accountant's report tracing $240,000 in equity draws and the closed CD funds into your company's operating account. His smile faltered. I laid it out calmly, the way Mr. Okafor and I had practiced. The date the power of attorney was filed, the dates of each equity draw, the exact account numbers the wires landed in, the recordings of him describing it all as simplicity and consolidation. I'm not angry to hurt you, I told him. I'm here because I need you to understand this is finished. I've already spoken with a lawyer. I've already filed a complaint with the bank's fraud department and with the state's Adult Protective Services Division for Financial Exploitation. My attorney is preparing to petition the court to revoke the power of attorney and to pursue restitution. Daniel's face moved through several things at once. Denial first. I was going to pay it back. I was just short-term borrowing, then excuses. You said you trusted me with everything. Then finally silence, because there was nothing left to argue against numbers, dates, and his own recorded voice. You are not managing anything of mine again, I said. Not my accounts, not my house, not my trust. That part of us is over. What happens next is between you, the bank, and the law. Renee sat quietly beside me, her hand on my shoulder, saying nothing, because nothing needed to be said. The room was very still, and for the first time in months, I felt like the one in control of my own life again. The bank's fraud investigation confirmed what Priya had already found. The notarization on the power of attorney had been signed off by a notary who, it turned out, was a friend of Daniel's and later admitted to notarizing the document without me actually present. A serious violation that cost her notary license. The court revoked the power of attorney within weeks, given the clear evidence of misuse. A separate civil case moved forward for restitution of the equity funds and the CD amount, with Daniel's own company records now subject to review by the accountant working with my legal team. The financial exploitation complaint led to a criminal referral because the amount involved crossed into felony territory in our state. Daniel eventually accepted a plea agreement that included probation, mandatory restitution payments, and a permanent record that ended any hope of the professional licensing he'd been working toward in his consulting field. His own firm, already thin on real clients, folded within the year once word spread quietly among people who'd once considered hiring him. I changed banks, closed every joint access line, set up a proper revocable trust with an independent, licensed fiduciary rather than a family member, and had new locks installed on the house, not out of fear but out of principle. Some doors, once someone shows you they'll use them wrong, simply need new keys. Daniel and I speak occasionally now, mostly logistics, mostly short. It is not the relationship I imagined having with my son at this age, but it is an honest one, which is more than I had before. It's autumn now. I'm sitting on my porch with a cup of tea, watching Renee's kids chase each other around the yard during their visit. The garden did well this year. Better than in years I wasn't paying such close attention to my own life. If there's one thing I learned, it's this. Love and financial oversight are not the same thing, and confusing them is how good people get taken advantage of by people they never expected to hurt them. Paperwork deserves the same attention as people, because paperwork is often how trust gets quietly rewritten, and boundaries, even with your own children, are not betrayal. They are protection. I don't regret giving Daniel a chance to help me. I only regret not reading more carefully what I was signing. If you were in my place, what would you have done? If you want more stories like this, hit like, subscribe, and watch the next one. That's what I told myself on that quiet autumn evening, watching Renee's kids run across the yard. I thought the worst had already happened and passed. I was wrong. What I didn't know yet was that the hardest part of this story hadn't started. Almost 5 months after the court finalized the restitution order, a letter arrived from a law office I didn't recognize. Not Mr. Okafor's office. A different name, a different city. Inside was a formal notice. Someone was petitioning to be added as a co-trustee on the very trust I had just finished setting up to protect myself. The name on the petition was not Daniel's. It was Marissa's, the woman Daniel had been dating for the past year. Someone I had met exactly twice, both times at short, polite family gatherings where she said very little and smiled a lot. I read the letter 3 times before it made sense. Marissa claimed she had been informally assisting me with financial matters for months, citing a handful of visits she'd made to my house. Visits I remembered only as friendly, casual coffee stops, sometimes with Daniel, sometimes I realized uneasily, without him. At the time, I didn't understand how someone I barely knew could file paperwork like this. Looking back, that confusion was exactly the point. I want to be honest with you. Even after everything with Daniel, I still let my guard down in small ways. Because I am by nature a trusting person, and that isn't something a single hard lesson erases completely. Marissa had started visiting more often after the court case ended, always with a reason. Bringing soup when I mentioned a cold, helping me organize a drawer of old paperwork, since Daniel told her I'd been overwhelmed by documents lately, asking gentle questions about my new trust, who the fiduciary was, how often I met with them, whether I found the paperwork confusing. I answered honestly, the way you do with someone who seems kind. I didn't think to wonder why a woman I barely knew wanted to understand the exact structure of my financial protection. There was a moment, maybe 3 weeks before the letter arrived, when she asked to see just the first page of my trust documents out of curiosity, since Daniel mentioned how complicated it all was. I remember hesitating, just slightly before showing her. That hesitation, small as it was, turned out to be the only instinct in this whole second chapter that was working correctly. I called my fiduciary, a licensed professional named Mr. Whitfield. The same afternoon the letter arrived. He read it over the phone with me and explained, in plain terms, what was actually being requested. This isn't a small administrative request, he said. A petition to add a co-trustee, especially one with authority over distributions, is a request for real control over the trust's assets. If granted, she wouldn't just be helping. She could authorize transfers. I asked how someone could even file this without my direct agreement. Some jurisdictions allow a petition like this to move forward if the petitioner claims informal caregiving involvement and the trust's current beneficiary doesn't object in time. It relies on people either not noticing the notice or not understanding what they're looking at. I sat with that for a long moment. It wasn't a forged signature this time. It was something quieter, an attempt to walk through an open door before I even realized it had been left ajar. I thought about the first page of my trust I'd shown her weeks earlier. She hadn't needed a forged signature. She'd needed information, and I had handed her exactly enough. Someone I had let into my home, thinking I was simply being kind to my son's girlfriend, had used that kindness to try to insert herself into control over what remained of everything I'd worked for. I called Mr. Okafor that evening. He didn't sound surprised, which unsettled me more than if he had. This happens more than people realize, he said. Sometimes it's not the original person who did wrong. Sometimes it's someone connected to them, watching from the side, learning exactly what worked and adjusting the method. He explained our options plainly. We could formally object to the petition, which would require Marissa to prove her claims of caregiving, involvement in front of a judge, something he doubted she could substantiate with anything beyond a few coffee visits. We could also request the court review whether the petition was filed with accurate information, since nothing about her visits matched primary caregiver in any meaningful legal sense. But, he added, objecting on paper alone sometimes isn't enough. Judges want to see the full picture. If there's any coordination between her and Daniel behind this, that matters. That was the real question sitting under everything. Was Marissa acting completely on her own, hoping for a smaller version of what Daniel had already lost? Or was this a second attempt, run through someone with a clean record, someone the court hadn't already flagged? We decided calmly and carefully to find out before the hearing date arrived. I didn't confront Marissa. I didn't confront Daniel either. Mr. Okafor was firm about this. Emotional accusations without proof had already cost me once, back before I understood how to build a case instead of just feeling wronged. Instead, I did what had worked before. I stayed exactly as approachable as I'd always been. When Marissa called to check in, I let her. When she asked gently whether the court date felt stressful, I told her honestly that I found the whole process confusing, which was true and which also happened to be the version of myself people seemed most comfortable trying to take advantage of. During one of these calls, she mentioned, almost in passing, that Daniel thought it might help if I was involved, since the court already knows him too well. I said nothing accusing. I simply said, that makes sense, and let the silence do the rest of the work. Mr. Whitfield helped me request the phone carrier records tied to the trust inquiry, since state law allowed a beneficiary to see communication logs connected to petitions filed against their own trust. Those records showed something Marissa hadn't mentioned: 3 calls between her number and Daniel's in the 2 weeks before the petition was filed, including one the same afternoon the paperwork was submitted to the court. It wasn't a smoking confession. but paired with her own words on our recorded call, the same lawful, one-party consent method Mr. Okafor had confirmed was fine before, and it painted a picture no judge would need much help understanding. Once again, I felt that same quiet steadiness settle over me. Not anger, just clarity and the sense that the truth, given enough patience, tends to organize itself. The hearing was smaller and quieter than I expected. No dramatic courtroom scene, just a conference room with a judge reviewing documents at a table, along with Mr. Okafor beside me, and Marissa with her own attorney across from us. Daniel was not present, though his name came up more than once. Marissa's attorney opened by describing her as a concerned family friend who had simply wanted to help an elderly man she cared about. Mr. Okafor responded calmly, laying out the timeline. The trust's low-detail first page she'd asked to see, followed weeks later by a petition requesting exactly the kind of authority that page didn't cover, which meant she'd have needed more information than casual conversation could explain. The phone records showing coordination with Daniel, including the same-day call to the filing, and finally the recorded conversation where she referenced Daniel's involvement directly in her own words. The judge asked her a few direct questions about her actual caregiving involvement. She could not name a single medical appointment, prescription, or ongoing responsibility, only visits and conversations. The petition was denied. The judge noted plainly that the filing appeared to lack the substantiated caregiving relationship required, and cautioned that further filings without such support could be treated as an abuse of the court's process. It wasn't dramatic. It didn't need to be. It was simply the truth, laid out clearly enough that there was nothing left to argue. Marissa and Daniel's relationship did not survive the fallout, though not for the reasons either of them likely expected at the start. Renee heard through a distant family friend that Marissa had been under the impression the trust petition, if successful, would have quietly benefited both of them, and that Daniel had encouraged the idea more than he ever admitted to me directly. When I finally spoke to Daniel again, briefly by phone, he didn't deny knowing about the petition. He said only that he'd thought it might fix things without dragging me through more legal stuff. I told him calmly that involving someone else in an attempt to access what the court had already protected wasn't fixing anything. It was simply trying the same door with a different key. Mr. Whitfield and Mr. Okafor helped me add an additional safeguard after that. Any future petition involving the trust would automatically require a mandatory notification directly to me and to a second independent attorney before any hearing could proceed, closing the quiet gap that had let this second attempt slip through in the first place. I also made a decision I hadn't fully considered before all this. I asked Renee calmly and without pressure whether she would be willing to serve as a named successor beneficiary, overseer alongside Mr. Whitfield, someone from the family who actually had nothing to gain by taking, only by protecting. She agreed without hesitation. It's winter now, several months past that hearing. Renee visited again last week, this time staying a few extra days. We spent one afternoon simply going through my paperwork together. Slowly, both of us actually, reading every line instead of trusting that someone else already had. I realized something sitting at that table with her. The first time, I lost money and trust because I didn't look closely enough at what I was signing. The second time, I nearly lost more because I didn't look closely enough at who I was letting close to me, even with good intentions on my part. Protecting yourself, I've learned, isn't a single decision you make once and then relax. It's something you keep doing calmly, patiently, for as long as people know there might be something worth taking. I don't say that with bitterness. I say it the way you'd describe locking your door at night. Not because you expect danger every evening, but because it's simply the responsible thing to do. If there's a second lesson from this part of my story, it's this. Betrayal doesn't always come back through the same face. Sometimes it comes back wearing a kinder one, moving slower, asking softer questions. Pay attention anyway. If you were in my place a second time, would you have caught it as quickly? Or would kindness have made you hesitate the way it almost did for me? If you're enjoying stories like this, make sure you're subscribed, because there's more of this journey still to tell.